Welcome to another episode of the Mushroom Murder Trial podcast, where I try, mostly in vain, to understand Erin Patterson. My name is Lisa and I'm a podcaster and a journalist, and thank you so much for joining me. Now, mushroom killer Erin Patterson is going to be made to sit through a 2-day plea hearing next week, when those impacted by her deadly Beef Wellington crimes will detail how her murders have impacted their lives. Patterson's pre-sentence hearing, also known as a plea hearing, provides an opportunity for the loved ones of victims to tell the court about how the crimes have affected their lives. So, will she look them in the eyes? Or will she cover her face with tissues and steadfastly cling to her belief that she's the one true victim? During her trial, it was reported Erin and her estranged husband, Simon Patterson, for just one moment locked gazes. What will she do next week if he makes an extended statement before the court? Will she hide her face or sob or glare at him like she did at some journalists in the courtroom? And I'm upset. I haven't had a glare yet, but then I've always been in the spillover room and not actually inside where Erin is. But you can live in hope, perhaps next week, who knows? So the Patterson and Wilkinson families have been praised for their poise and dignity during the legal process. So I'm not expecting anything unconventional from them, partly on account of their deep Christian faith. But praise often comes in different ways, and one of the most high-profile victim impact statements of recent times have been from the Idaho 4 families. The sister of University of Idaho murder victim Kaylee Goncalves said everything in her body told her to run as she came face to face with the killer, Bryan Kohberger, during his sentencing. But instead, she delivered a powerful, blistering takedown of her sibling's killer. Olivia Goncalves described the mass killer as a, quote, sociopath, and even ordered him to sit up straight in the courtroom. Quote, disappointments like you thrive on pain, on fear, and on the illusion of power, and I won't feed your beast. Instead, I will call you what you are, sociopath, psychopath, murderer, she said, adding, sit up straight when I talk to you. I just wanted to add that again because that is just, in my opinion, it's a great thing to say to a psychopath because they can do nothing about it. Now, I imagine if Erin got that, she would absolutely be traumatised, or she might correct someone's grammar. It just depends how far it's kind of penetrated into her consciousness. But the sentencing hearing is coming just a month since the jury found her guilty on 3 counts of murder and 1 count of attempted murder. Now, she served the lunch spiked with the death cap mushrooms to 4 of her relatives. The 50-year-old's lawyers will make arguments on behalf of their client. Now, I read, and I don't know if this is true, we'll find out, but there have been indicators that Erin, yes, that's right, Erin, is going to appeal. That is the most Erin thing ever. Anyway, we'll go back to where we were. Apologies. And any factors that could be considered by the court when deciding on her punishment. In Victoria, the standard sentence for murder is 25 years, but the crime carries a maximum penalty of life in prison without parole. In a hearing earlier this month, Justice Christopher Beale asked prosecutor Jane Warren how many people would be making victim impact statements. She said one of the 2 days would be likely filled up with the reading of a, quote, a lot of statements. According to Victoria Legal Aid, we will hear a legal statement describing how the crime has affected a person. It will be used then as part of the sentencing purposes. The New South Wales Judicial Commission explains the rationale behind these statements as such. In Munda versus Western Australia 2013, the High Court referred to the role of the criminal law as including, quote, the long-standing obligation of the state to vindicate the dignity of each victim of violence, to express the community's disapproval of that offending, and to afford such protection as can be afforded by the state to the vulnerable against the repetition of violence. Further, one of the historical functions of criminal law has been to discourage victims and their friends and their families from resorting to self-help and the consequent escalation of violent vendettas between members of the community. Self-help. Maybe that's how they viewed it back. When was this? 2011? 2013, that was self-help. I think we think of it differently now. We don't think of it as vendettas, but I shall go on. In His Honour's article, Civil or Criminal, What is the Difference? Former Chief Justice Murray Gleeson observed that, quote, one of the most notable changes in the administration of criminal justice in recent years has been a growing awareness of a need to take account of the impact of offences on victims. In some jurisdictions, provision is made for evidence of victim impact to play a formal role in sentencing procedures. In addition, the common law requires judicial officers to have regard to the effect of the crime on the victim. The undoubted proposition that a sentencing judge is entitled to have regard to the harm done to the victim by the commission of the crime. That is the rule at common law. Now, a sentencer is entitled to consider all the conduct of the offender, such as damage, harm, loss occasioned to the victim, cannot take into account circumstances of aggravation which would have warranted a conviction for a more serious offence. The reference there is the Queen versus D. Simone, 1981. The common law rule is that the court can only have regard to the consequences of an offence that were intended or could reasonably been foreseen. That's Jeffesky versus the Queen. The offender takes the victim as they find them. That's interesting, isn't it? So Section 3A of the Crime Sentencing Procedure Act of 1999. Are you guys bored yet? Hope you're not too bored. I just think it gives us a context. Provides that one of the purposes for which a court may impose a sentence on an offender is to recognise the harm done to the victim of the crime and the community. So, who can do a victim impact statement? Quote, immediate family is defined broadly to include the victim's spouse or de facto partner, a person to whom the victim is engaged to be married, a parent, grandparent, step-parent, child, grandchild, stepchild, sibling, half-sibling, step-sibling. For proceedings that commenced on or after the 27th of May 2019, the definition extends to step-grandchildren, aunts, uncles, nieces and nephews, persons who are close family or kin according to Indigenous kinship systems, or other persons the prosecutor is satisfied is a member of extended or culturally recognised family, or who the victim considered to be family. Now, you don't want to go too far here, because when you're looking at the relevance of vengeance or forgiveness, in terms of forgiveness, just because the victim or their family, etc., is forgiving, it doesn't actually mean that that lessens the impact of the crime. So in R versus Paul, 2002, in the New South Wales Court of Criminal Appeal, Howie Justice with Levine and Hidden JG agreed, said, the attitude of the victim cannot be allowed to interfere with the proper exercise of the sentencing discretion. This is so whether the attitude expressed is one of vengeance or forgiveness. R versus Glenn, New South Wales Court of Criminal Appeal, 1994. Sentencing procedures are not a private matter between the victim and the offender, not even to the extent that the determination of the appropriate punishment may involve meting out retribution for the wrong suffered by the victim. A serious crime is a wrong committed against the community at large, and the community is itself entitled to retribution. In particular, crimes of violence committed in public are an affront to the peace and good order of the community and require different deterrent sentences. And then there's Henderson from the New South Wales Court of Criminal Appeal, 1997, matters of general public importance are at the heart of the policies and principles that direct the proper assessment of punishment, the purpose of which is to protect the public, not to mollify the victim. Now, as well as this, there can be a direction for compensation made to victims. And in Victoria, victims of violent crime can receive financial assistance through the Financial Assistance Scheme to help with costs related to their recovery. So things such as medical costs, counselling, safety-related items, loss of income, and in some cases, special financial assistance to recognise the harm caused by the crime. So who is eligible? Primary victims, so individuals who have suffered directly from a violent crime. Secondary victims, that's close family members, and witnesses. The assistance can also pay for loss of income, medical expenses, clothing damage during a crime, and special financial assistance. Now, special financial assistance, it happens and it is an additional payment separate from the other financial assistance that is provided in recognition of the harm caused by this crime. Interim assistance, if you need it, you can ask for it. So, late last month, the Victorian Supreme Court placed a restraining order over Patterson's Leongatha home, where the deadly lunch unfolded. This order prevents her from selling the home and preserves the property for a possible claim for compensation or restitution, which is very interesting if she's going to appeal, and whether legal aid will take it up if she can't sell that house. Who knows? My husband and I were having a debate about how much we think it's worth. This is what I can tell you. I think from memory, she bought it from $248,000, and then she built the house. Okay, and she's done a bit of work on the landscaping and everything, and the property market's gone up since 2019. Who wants to make a guess? I'd love to hear what you think. So that is all I have for you today. Thank you so much for listening. I have a few thank yous, actually. Firstly, to the wonderful listeners on Reddit, especially the one who said I was like a nosy neighbour. That is exactly how I like to be perceived. So thank you so much, because I know Erin a bit, right? And I like to talk to you guys as though we're chatting over the back fence, and we could do this for hours if we need to. I also want to thank everyone else who's contributed to the cost for my trip to Melbourne. I will be there with bells on. I've booked everything now, but you can still, if you want to, contribute to Buy Me a Coffee link in the show notes. I'd appreciate that, but only if you can afford to. But thank you. I'll be bringing everything to you next week, straight from Melbourne, the Supreme Court there. So thanks again, and I shall speak to you very, very soon. Bye.